Hi, welcome to part one of Introduction to Sentencing. For those of you who don't know me, my name is Brandon Kelley. I'm the Associate Director of Debate at Georgetown, so one of Georgetown's two full-time coaches, in addition to Michaela Mawson. I'm going to go ahead and to kind of introduce the evidence-based sentencing app, break this up into two parts. This first part is going to be kind of a brief overview of the basics of sentencing, kind of what it entails, the history of it in the United States, and kind of what brought us to the present moment. I'll then kind of talk a little bit about evidence-based sentencing itself, what it means, what it involves, and what the various sets of kind of proponents and critics are excited about and concerned about. And then that will constitute the end of part one. Part two of the lecture will dig straight into a discussion of the EBS app itself, as well as the MEG, and kind of cover the more debatey sides of this. So, excuse me. So first of all, to kind of introduce sentencing briefly, sentencing is the phase of the criminal justice process that occurs kind of immediately following someone being found guilty of a crime, right? And so that conclusion of guilt can come about either because they had a trial and were found guilty, or because they plead guilty as part of a plea bargain. And the kind of phase immediately following that is sentencing, at which, quite appropriately, and as the name would suggest, someone kind of receives their sentence, right? And the way that works is you will go before a judge who tremendously, and I'll talk about this more in a second, has had tremendous discretion to determine the sentence that someone deserves as a result of the crime of which they've been found guilty, and kind of hands down the details of their sentence. And what that entails is, do they get jail? Do they get probation? Do they get some form of supervised probation, community service, a fine, etc. And then also, kind of within each of those sorts of categories, how severe will that sentence be? How many days or years are you going to spend in prison, and so on. And so kind of the thing to note from the outset, like I kind of alluded to a second ago, is that judges traditionally have had an enormous amount of discretion to determine sentences. So, historically, the judge that was handing down your sentence would consider a wide array of information and decide what kind of you individually deserved or didn't deserve in terms of kind of the severity and harshness of your sentencing. The rationale underlying that is, well, kind of manifold, but at its root, it's, I think, productive to think of it in terms of kind of like level of guilt as part, is one part of it. So I guess taking a step back, there's a broader question here about kind of what the purpose of our criminal justice system is, right? And what is the role of punishment? Why is punishment desirable? And what purposes do we want it to serve? And so this will kind of become very relevant as we get into the EBS part itself here in a minute, but there's, that's kind of an initial threshold question, and there are lots of different competing answers to that kind of cut in different directions and would compel you toward different kind of solutions and prescriptions, right? So if the role of punishing someone is to deter other people from committing a given crime, then maybe it's really useful to be very harsh and kind of make an example of that individual. In contrast, one could conceive of punishment as in retributive terms, right? So we punish people because they committed a crime, and doing so is kind of a moral failure, and you deserve some amount of negative done to you in response. So like atonement almost, right? And then there's another way of thinking about this that is much more focused on kind of rehabilitation and even mercy, like that the role of punishment is to correct the behavior of the individual in question, and then integrate them back into society as kind of efficiently and effectively as possible. Another rationale that's really important is kind of protecting public welfare, right? So maybe the reason that we put people in jail is to protect the public from those people. In actuality, at least in the United States, the criminal justice system definitely, incorporates a blend of each of these things. But the reason I kind of started by saying this is it speaks to the sentencing part, insofar as part of the rationale for judges having that much discretion historically is that for kind of each one of in terms of balancing each of those considerations against each other, but also to effectuate each individual one of those. For example, like the giving people kind of their just desserts, right? The retributive understanding of justice. In order to do that, you need to make a very highly individualized, kind of highly personalized determination about an individual's level of blameworthiness and kind of how severe the crime should be understood to be. Because two people committing the same crime may have done so for very different reasons. They may have been compelled by very different circumstances, and we kind of societally may be much more understanding of one of those rationales or whatever than the other, right? Similarly, if your goal is to like ensure that the person reforms, then their history of crime and stuff is quite important. It's like, and same thing for public welfare. It's like if this is somebody who we have reason to believe is going to be extremely dangerous and is likely to kind of murder someone else if they are not in prison, then that is a very different situation than somebody who very clearly genuinely kind of heavily regrets what they did and that sort of thing, right? And so as a result of all that, since the 1840s, many jurisdictions, including federal courts, have had a pretty standardized practice of having a probation officer prepare what's called a pre-sentence investigation report. So immediately, like as kind of the first stage of the sentencing process, the probation officer will gather together a lot of different information about an individual defendant's characteristics. So that will include their their criminal record, if any. It typically also includes a bunch of information about their kind of personal circumstances, their level of educational attainment, their financial circumstances. They often will interview a bunch of people who know and have interacted with the defendant, and kind of like try and get a holistic sense of what they're like as a person. They will sometimes interview the family or family members to kind of add additional pieces of information to that puzzle. And the goal of all of this is just, again, to create as kind of a holistic picture, as holistic of a picture as possible, that the judge will then, kind of take and review and sort through all of that. And also, through some combination of that and what crime the person actually committed, what law they actually broke, and how serious the law thinks that is, will kind of come to a determination about what the sentence should be. So, like I said a minute ago, traditionally, in terms of making that determination, the judge had tremendous latitude and discretion. They could largely kind of decide that the person deserved or didn't deserve more or less whatever they wanted. This changed, and so a really important kind of pivotal moment in the history of sentencing in the United States is when this changed in the 80s. So in the 1970s, there was a very large crime wave in the United States, and that kind of continued into the 80s. And one major way that both that initially individual states in the United States and then eventually Congress, which I'll get into momentarily, one way they responded to this was beginning to curtail judicial discretion at sentencing by requiring that the response be somewhat harsh. The rationale being that they could kind of either deter people from committing these crimes, or the people who were undeterrable, stick them in jail. And so, in order to kind of protect public welfare. And so, like I said a minute ago, the crime rate was extremely high. And so into that kind of situation, you had a really interesting moment where Congress kind of got together. They passed what's called the Fair Sentencing Act. But what was interesting about this is on the right, you had, conservatives who were, like I said a minute ago, very worried about crime. They were like, these judges are being too nice to these people. The solution to this is we need to crack down. And on the left, you had a very different concern. And that was these individual judges were sentencing people in ways that, had very large kind of measurable racial inequalities baked into them, right? So your average Black person was significantly more likely to be incarcerated and for significantly longer. At least that was kind of the theory. than your average white person. And so the way that Congress decided to resolve this was through this act that put in place what are called mandatory minimums, which is it's exactly what it sounds like, right? It's a minimum sentence below which one is not allowed to deviate when sentencing someone for a particular crime. So, if you commit crime X and there's a mandatory minimum attached to X of like 3 years, then the judge can take into consideration all these different factors like they normally would, and they can decide to sentence you to more than 3 years, but they cannot sentence you to less than 3 years. Another major element that kind of began to crop up increasingly over the course of the 90s and into the early 2000s, or 80s, 90s, and early 2000s was what are called 3 strikes laws. So a law that clearly establishes that if you commit, if you're found guilty of a crime, at least that meets certain parameters, depending on the 3 strikes law in question, 3 times, then you suddenly incur a much more significant penalty. And there too, the rationale, at least in theory, was deterrence. Like if you, instead of kind of having it be more or less the same or increase kind of linearly over the course of these crimes, you have this point at which the amount of prison time you're guaranteed spikes from like 5 years or whatever to 20 years, then the theory is that will kind of prevent people from committing those crimes in the first place. As a result of this drastic curtailment of traditional kind of judicial discretion in sentencing, life imprisonment skyrocketed. So between 1992 and 2003, there was an 83% increase in the rate of kind of incarceration for life. There were also much broader increases in both sentence length and severity and level of mass incarceration. And some of that is for a set of reasons distinguishable from this, including kind of much more aggressive policing via the war on drugs, et cetera. But a whole lot of it is down to sentencing. Now, additionally, the impact of all of this, kind of directly counter to what the people on the left had been pushing for in terms of their kind of entry into this bargain, is that the inequality in sentencing also exploded. It was not great before. It is very not great now. And there is definitely some variation in terms of kind of how those effects have played out over time and in various different places. For a complicated mix of kind of interrelated reasons that we don't really get into right now, but it is definitively clear, although occasionally I have someone arguing to the contrary, but the evidence is quite decisive that mandatory minimums have an enormous racialized effect on kind of sentencing outcomes. And we'll kind of get to why that is here in a minute. One particularly notorious, kind of much more targeted way in which this has been true that you all have, likely heard about at some point, is the differences in sentencing between crack cocaine and powder cocaine. And so the reason for that is that there was a 100-to-1 ratio between the amount of time that one would need to serve for being found guilty of possession or use of a given amount of crack cocaine relative to powder cocaine. Despite them being, there are some differences, but for the most part, very similar. And the core difference really is that Black people were overwhelmingly more likely to, who were using cocaine, were overwhelmingly more likely to be using crack. Something like 96% of people arrested for crack use were Black. And a very similar proportion was true for white people the other direction, like upwards of 90% using powder cocaine were white. And the reason for that is just boils down to the fact that like one of those is much more expensive than the other, and is therefore kind of much more of a rich person's drug. And historically in the United States, that also means a white person's drug. So yeah, not great. A couple of things that are worth noting here. So the first is that when the Sentencing Reform Act of 1984 that I talked about a little while ago was passed, I think I may have actually called it the Fair Sentencing Act. That's incorrect. It put in place a set of federal guidelines, the U.S. Federal Sentencing Guidelines, that were created by a commission that act established, the Sentencing Commission. And those guidelines lay out a uniform policy for how to go about sentencing individuals who are convicted of either felonies or very serious, i.e. Class A misdemeanors in the federal court system. And initially those were understood to be mandatory. And so judges were kind of required to hand out these much harsher sentences. Like we talked about earlier, that was driven by kind of a mix of, we want to reduce the kind of individual racial bias effects that are resulting in sentencing variation, and at the same time want to kind of sentence pretty aggressively and systematically and in a very predictable way in an effort to deter and systematically decrease the large crime wave in the United States. In 2005, though, the US Supreme Court held in a case called United States v. Booker that those guidelines, as they were initially constituted, violated the Sixth Amendment, which guarantees the right to trial by jury. And so the remedy that the court chose was to excise those provisions. In the course of doing so, making the guidelines voluntary, right? So initially, everyone understood those guidelines to, be mandatory and binding on federal judges. After this court case, those guidelines were exactly that. They were guidelines. And so they're still around. They are still used extremely, extensively. They are typically, judges will kind of use them as a jumping off point, the point of departure, to kind of give them a general benchmark for how to sentence a given crime, what, the penalty for that ought to, in general, look like. But judges are no longer required to fully abide by that, and by extension are allowed to kind of take into consideration a bunch of additional variables like they used to be able to, and kind of like I described at the beginning of this lecture, in a way that for a period there they kind of were not able to. And so you will sometimes have instances where a judge will, in minor or major ways, refuse to kind of abide by those guidelines or apply them in a given context, and that is absolutely lawful. They, can do whatever they want in that respect. Yeah, so that takes care of kind of some of the initial basics of sentencing. The next thing that I want to pivot into, and this lecture is getting a little bit long, so I'll just speak to this briefly and kind of tee it up for the next video, is evidence-based sentencing. So evidence-based sentencing, or EBS for short, refers to the use of what are called actuarial risk assessments. In other words, in the same way that, for like the insurance industry or something, you would assess the risk that a given person kind of like, won't, or for lending, you would assess the risk that a given person won't repay their loan. For insurance, you would assess the risk that you will need to pay out, whether because they, for health insurance because they might get a disease, for auto insurance because they are an unsafe driver or whatever, right? So like taking all of these different variables, all these different characteristics of a person, putting them together into an algorithm and trying to spit out a number that gives you a general percentage probability that they will do the thing that will kind of cost you in some way, right? So that's an actuarial risk assessment. Evidence-based sentencing refers to using those as part of the sentencing process. So instead of just taking and compiling kind of a dossier on the person, like I described earlier, they will do that, but include as part of that the recommendation of an algorithm that takes a bunch of takes a bunch of characteristics of the individual, for example, like your background in terms of level of educational attainment, what neighborhood you live in, how old you are, whether you're male or female, often your level of income, what kind of job you have, whether you've been convicted of a crime in the past, and if so, what crimes have you committed in the past, a whole range of different things. Some algorithms use some variables, some use others, in different combinations and with different weights, but that's kind of the set of stuff that we're talking about when we talk about actuarial risk assessments. And so the number that spits out is a measure of the probability of what's called recidivism. So recidivism refers to the likelihood of reoffending, i.e. committing another crime, and thereby kind of like re-entering the criminal justice system. And so what these assessments measure is or attempt to predict, rather, not measure, but like attempt to predict, is the likelihood that a given person will end up reoffending at some point in the future. That metric is then used as kind of another input that judges consider in the sentencing process. We will talk a little bit more about that and why that is problematic, why proponents like it, why critics hate it, and then use that as the springboard for getting into the affirmative and negative available to you in the next video. See you then.